And again, I'm speaking very specific to Georgia because it is going to vary from state to state, but there are uniform acts that have been, different states have, most of the states have enacted these uniform acts. So it should be similar, but I'll make a point to some of the significant changes in the process. But in Georgia, it's filed by a petition with the probate court. Probate courts in Georgia have the exclusive jurisdiction. They are the ones that are allowed to hear these cases, and only the probate courts. So two people have to file a petition. It can be two people with personal knowledge. It can be one person with personal knowledge and a doctor, psychologist, or a social worker, licensed clinical social worker, who has done an evaluation. And they file the petition with the court. And and then the court does a review of the petition. Has this person said enough to make me think that that the proposed ward, that's what the individual is called, the proposed ward, that they lack capacity to make or communicate significant responsible decisions with respect to health and safety or management of their financial affairs. If that part has been pled sufficiently, then our court will order an evaluation of that, an independent evaluation of that person. And this varies from community to community. Sometimes you have to arrange the evaluator. Sometimes the court has a list of evaluators. Sometimes the evaluator will come to your house. Sometimes the house of the proposed ward. Sometimes you have to go to the evaluation. It really just depends on what jurisdiction you're in. And then that evaluation will be filed with the court. And assuming, again, that evaluation is consistent with the initial pleading, then the court will go ahead and order a hearing. Also, before the evaluation, the court should appoint an attorney to represent the proposed ward. Because remember, I'm going to make an analogy here. It's similar to a criminal action in that we are looking at removing somebody's fundamental rights. And so the attorney is there to make sure that the individual's due process rights are being protected, that their civil rights are being protected, and that everything is going as it should be going under the statute, that we're not railroading somebody into losing their fundamental rights. And at the next stage, though, we do have a hearing, and it's an evidentiary hearing where you have to present, as the petitioners have to present evidence that this person needs a guardianship or conservatorship. If assuming that burden is met, then the court will, in most cases, require a criminal background check. If you're the conservator of their assets, you have to be bonded so that you don't run off and start a vineyard open a vineyard in France with the money of the ward. And then you have reporting requirements. You file reports within 60 days of being appointed. Receiving what are called letters. I'm getting very technical here, but you are essentially within 60 days of your appointment, you file reports with the court, and you have to file reports annually within 60 days of the anniversary of receiving your ability to serve as guardian and conservator.
Do you have to hire a lawyer to seek a guardianship or a conservatorship?
No, actually, generally speaking, Georgia is very friendly. And again, a lot of it is done by form. Now, also, I have served as court-appointed attorney. I did that for a number of years. And when I was a court-appointed attorney, I did work with, you can't really present legal advice to the other side, but sometimes you might suggest options. If you felt like that person maybe needed assistance, that maybe we would suggest they hire an attorney, or that they review the literature that is published by the probate court. So generally, no. If there is any kind of family dispute, anything that's kind of funky, family members that don't get along, if you're doing this because somebody's stealing from mom, you probably want an attorney, because sometimes there are complexities with those issues that just an attorney is going to help you with those. Never do a guardianship or conservatorship or represent yourself in a guardianship or conservatorship matter if a case has been filed and you're going to challenge, or the language is contest that case. Don't challenge a case on your own. All right, that really does require an attorney and that knowledge that the attorney can bring to the table.